topic, one of the topics that we are going to speak, which is the equity release. It's not very well known, and I would say Spanish citizens, but it's starting to be used, and in terms of this financial product, obviously we would like to explain how it works. In this case, in Spain, Darcy will be providing us, I would say, valuable insights of this, and what are the option works, how it works really this, and obviously particularly with Spanish owners or owners of Spanish property. Sorry. Hello, Darcy. Good afternoon.
Hi, everyone. Thank you very much, Pedro, for introducing. Nice to see everyone here. And yeah, I look forward to sharing my presentation.
Thank you. Let me also, I'm going to introduce, but it still has not started. Obviously, I can see that Ignacio is here. And Ignacio is one of the, I would say, respected legal experts in the field of inheritance and wills in Spain. Hello, Ignacio. Good afternoon.
Hello, Pedro. Good afternoon, everyone. I made it.
Okay, Ignacio Pellicer from pellicer.com. Ignacio will bring a deep, I would say, practical knowledge, obviously, about inheritance tax, about wills, about tax planning. At the end, about estate planning, on how to prepare the future when it comes, and how to navigate into the Spanish legal system that sometimes is complex, but obviously we will explain, and he will be explaining with clarity and I would say also confidence. Okay, well, and also will be joining us Michael Davies. He's also a highly experienced lawyer with a strong focus, I would say, in wills and inheritance matters in Spain, and will be giving us some light on the legal side of obviously experience, precedents that obviously he's well known and normally in the Andalusia area in the south of Spain, where he's highly experienced. So let's start with Darcy in terms of, well, in order to start, giving us some lights about how it works, really, the equity release. All yours, Darcy.
Brilliant. Thank you very much, Pedro. Yeah, nice to see everyone here.
Well, also, sorry, Darcy, let me also, I forgot, sorry, Moody. Also, is joining us. I didn't say that. Sorry. And finally, Moody from Bay Radio, and will be helping us today of collecting questions that you may have in order to, at the end, probably at half an hour, we'll be answering questions and answers. Moody comes from Bay Radio. Bay Radio is one of, I would say, most listened English language stations in Costa Blanca, and obviously he will speak about here the Bay Radio as well. And hello, Moody. Good afternoon.
Hi, Pedro. It's easily done. Don't worry. And I was just having a count up there, and you said 3 experts, and I'm making sure you didn't include me in there.
No, sorry. I said 3 experts.
Very underqualified to be a part of this.
And obviously, you will be obviously guiding us in terms of what are the questions on the point of view from people that has these kind of issues or questions that obviously your point of view is well experience in terms of you understand what how people is going to ask and understand how if we explain it well or not in these cases.
Absolutely. So if they don't get answered along the way, then I shall pass those over to you. Certainly.
Okay. Well, thank you, Moody. Let's start with Darcy. Darcy, all yours.
Excellent. Thank you very much, guys. Yeah. So I just wanted to talk to everyone today about a product that's offered between Mapfre and partnered with Santander, be called the equity release, as Pedro said, or in other words, it is a reverse mortgage. So I'll just, if you don't mind, share my screen with you. Just want to check that everyone can see that well. Excellent, brilliant. So this is a Mapfre reverse mortgage partnered with Santander, a guide for expats moving into Spain. What is a reverse mortgage? A reverse mortgage is a loan taken out against the value of a property that a homeowner owns, aimed at individuals aged 65 and older. Unlike a traditional mortgage, homeowners do not make monthly repayments. Instead, they receive regular payments based on their home's equity. The loan amount accumulates interest over time and is repaid when the homeowner sells the property, moves out permanently, or passes away. The repayment responsibility will then fall on their heirs, who can either pay off the loan, sell the property, or relinquish the inheritance. So it's taking a loan against the value of your property. So the advantages of the reverse mortgage is that you, one, continue to live with your home. You can retain ownership whilst receiving additional income. Two, there are tax benefits as well. The monthly payments that you receive through the reverse mortgage are not subject to personal income tax. And three, it offers financial flexibility. The monthly payments will supplement your retirement income, and you have an option to convert payments into a life annuity. For protection for your heirs, the heirs can choose to keep the home by repaying the mortgage, sell the property, and retain remaining funds after repayment, or three, renounce the inheritance. And there's no personal liability for the debt. If the home sale does not cover the debt, the entity only claims a mortgage property, not personal assets. Very interesting. So some of the limitations is that there's a reduction in home equity. The home value can decrease due to accumulating low interest. Two, the heirs have financial responsibility. They must decide whether to repay, sell, or renounce the home within 9 months. Three, there's property eligibility requirements. The property value has to have a minimum of value of 200,000 euros, and it has to have no existing mortgages or anything else attached to the property. Also, there's limited duration of payments. The payments stop after a set period unless converted into a life annuity, which again can incur additional costs. And five, there's potential taxation on a life annuity, subject to regulations, which I'm sure the guys will talk to you more about later with the tax planning. So to apply, you need to meet the eligibility requirements, mainly being over 65, homeowner of a property valued at 200,000 euros or more. And that will be enough for us to be able to give you some more details regarding this, and we can prepare a quote for you, and the people at our company can provide financial advice. If you're interested in the Santander Mapfre reverse mortgage, here to help. Please contact me at darcy@pellicer.com for a personalized consultation. What I will do is I will leave my email in the chat just in case anyone wants to get in touch, and then I'll be able to send move through more information in the brochure.
Okay.
Yeah, so
Fantastic.
that's all. Thank you very much.
I mean, please, everyone who has some questions and doubts and things that would like to clarify, obviously, put you in the chat or any questions you may have. In terms of, we will happily read them with you, and obviously we'll try to give you an answer on this and how it works. Okay. As I said, it's extremely important to make some tax planning on whenever you're going to become resident in Spain. And not just in terms of income or in terms of future about what assets are worldwide or are in Spain. This is why we always recommend to make a tax planning and to organize the future, how you want to happen in terms of wills, and obviously to understand what will be the charges, what will be the taxes to pay in case your beneficiaries are going to receive some assets from you. This is why, I mean, Ignacio, he's an expert, and he is well experienced on this. And I would like just to give us summary, obviously, about the importance of making a will and about the importance of making a tax planning.
Mm-hmm. Okay, thank you very much for the presentation, Pedro. Thank you, Darcy and Moody. I'm sorry I was 5 minutes late, but I think we made it on pretty much on time. So right, Pedro. I mean, the importance today about talking about wills. Some client of ours ask about making a will, so they will leave everything to their beneficiaries, right? Obviously, alternatively, some client of ours said, Ignacio, Pedro, our children had enough of, they're wealthy, they have a good money, they don't need anything, we're a bit short, and we think that we need to use our equity. I really think, Pedro, that it was a great opportunity to introduce this product that in old days, you and me used to have it. Probably that was back in 2005 or 6, the equity release. I don't know if you recall, but yes, it was popular. Then they removed that. But thank God now it's back again, only for a specific population and for specific people with different requirements. So I really encourage, for those of you who are thinking about making a will, right? And if you're in this position, to try to do a simulation with Darcy just in case it works and it suits your interest, okay? Now, there is two ways in Spain. If you are either resident or non-resident, either fiscally or non-fiscally, it doesn't matter. But if you have assets in Spain, I highly recommend you to draw up a will and make a will, whether it's a Spanish will or international will drawn out in Spain. That's very important for your peace of mind and for your beneficiaries. Why is that? Because depending on your nationality and your residency, it will mean that if you pass away, the succession laws will apply differently. For example, you never made a will, you are British, and you are resident in Spain. I'm sorry to tell you that as you never made a will, the applicable law will be the Spanish law according to the bylaws, the European Act 650/2012 about international inheritance, right? So some people might say, nothing, well, but the UK or the US or different countries didn't sign that agreement. It doesn't matter. You are a resident in Spain, you've never made a will, therefore the applicable law is the Spanish worldwide here, right? Because you never made any commitments, you never chose any applicable law, and therefore you are obliged, or the beneficiaries are obliged, to go according to Spanish law. That might not really suit you for different reasons. One, you want to protect your wife, your husband, to start with. Two, you probably don't want to leave anything to children. Why? Because they already have their share, they're happy with it, and they don't need that. Or three, because you don't have beneficiaries for you to leave it, and therefore the state might repossess the state. The state will repossess your properties. So, number one advice all over the years we've been going through, and we've been signing thousands of wills here in Spain, international, more complex, more simple. Number one advice: try to speak to your lawyer, even to Pedro, to me, to any of your trust, about making a will to protect your loved ones and to minimize from a tax point of view. Why is that? Nowadays, we are now in Comunidad Valenciana, but we're licensed to operate the whole of Spain. Spain has different communities, autonomous regions, and every single one, depending on residency, will apply different laws to every state that they end up phasing on. So, bottom line, number one, make a Spanish or international will. Number two, just make very clear instructions who you want to leave everything to. Three, you could use the executors for you to instruct, like we have many of our wills with executors, about making a will, what you want. I normally say to clients, what would you like us to do? Because it will be Pedro, myself, or just our company to deal with the state. What would you like us to do? So we normally do a Spanish will, bilingual in two languages, Spanish and English, and then you will instruct us what to do with your assets. Then secondly, you will give us written instructions what to do or how to act on your behalf if something happens. I mean, we don't need to know the amount, but we need to know who to contact and what to contact, because we don't know at the time whether you'll have some money left in that bank account or not. But it's important for us to contact and try to cash anything in and spread it out between the beneficiaries. Now, the most difficult question, the most difficult thing now for you to know is how much tax you're going to pay. We could tell you today that inheritance taxes will be variable depending on the community that you are in and depending on the year that you pass away. For example, today we are in Spain, Comunidad Valenciana, and nowadays, thank God, there is no taxes pretty much after the allowance if you are a resident in this community. I thought Michael will join us, but he will exactly say the same in Andalusia, exactly in Madrid, which is quite good that if anything happens to you after the allowance, in this community, you have 99% off from whatever tax you end up paying. So that's very good. Now, Pedro, we don't know how much is going to last because, you know, the laws change in a regular basis, depending on politics and
Depending on
time.
politics and time, that's right.
Yeah. So the good news here, have you made a will? Yes or no? If you haven't, it is time for you to think about it. Okay, we could analyze whether the applicable law is Spanish, Dutch, British, American, Australian, specifically, and take it from there. Number 3, in the same appointment, we should talk about tax planning. What is more efficient? First thing you need to have on mind is your wishes. And secondly, what is going to be the cost of it? Okay, that's very good. Obviously, this is one of the requirements that I know from Darcy and Mapfre team that they want for the peace of mind that the beneficiaries want to, they have to agree with this product because they don't want any issues. According to the Anglo-Saxon law, basically common law, I understand that there is not any false heirs. However, they could always contest or say no, but I heard from Mapfre, and correct me if I'm wrong, Darcy, that they will want everybody, the whole family, to agree. Okay, so that's one of the other reasons that you need to have a will in place and leave everything well prepared. And basically, as I said, first, assets in Spain. If you have 0 assets, then obviously you don't have to worry about anything here with regards to the wills. If you have assets, important, what law is the applicable law now? Have you made a will? Under what law you've made it? Tax planning, how do you distribute your will? Do you distribute it in an expensive way? Probably you left it all to your sister and brothers, which is an expensive way, but that's what you wish, but you need to know how much is that. And executors, important. Just tell your executor how you want everything to be dealt with. Important as well, that from experience, the insurances, right? The insurances are not part of the will unless you mention specifically. What was the problem? If you ever had a life insurance and you never mentioned, because we had real cases like that, you end up having a will. You never mention about the policies, the insurance policies. If you never mention that, obviously that's going to be an issue. You could have a policy saying one thing and a policy obviously saying something different, and a will saying something different. Okay, so watch out there as well what you're going to say, and try to bring everything together to your solicitor. Okay, right. I don't know if I missed anything here about that. Executors is important. International wills is important. Tax planning now is very good in this community, is important. All the beneficiaries should sign as well. If you're going to go for the equity release, if you want to go for that, that's fine. I understand, Darcy, that you'll have to do a project depending on the age, the valuation of the property, etc., right? And I don't know, Pedro, I don't know if I tried to squeeze it in as much as I could to keep it simple. But yes, over to you, Pedro.
Yeah, at the end is just to obviously to give them scenarios that may happen when someone is resident or whenever someone is not resident, but normally when it's resident. And obviously, if we highly recommend to make a will. Firstly, because we have explained this many times. Firstly, because it's extremely important to be sure which is the applicable law. Just to summarize and rapidly explain it, we have a European Act from some years ago, from 9 years ago. It was approved in 2012, but it was starting valid in 2015. And it basically says, whenever you are resident in a European Union country, there are some exemptions with some countries, Denmark, Ireland, and it used to be also UK. When you are resident in some country, if you are resident applicable law of inheritance will be the residency law. So if you are resident in Spain, which is your citizenship, applicable law in inheritance will be a Spanish law. Spanish law have some, let's say, limitations on choosing who are your beneficiaries. So in order to break this rule and in order to choose who are going to be your beneficiaries accordingly to your national law, then you have to make a will and expressly say and written that you want to be treated in order to choose the beneficiaries accordingly to your national law, accordingly to your passport law. And in order to avoid Spanish law, because of Spanish law, I'm married, I have 2 children, I cannot give everything to my wife. 2/3 of my assets goes as an obligation to my children. So I cannot choose my, I don't know, the Swedish law, I cannot choose a British or any other law. I mean, but those ones who come from different countries and are residents in Spain can choose their home law. In order to, if it has some differences and it has some benefits in terms of choosing the beneficiaries. That's the first point, and in order to start the tax planning is making a will. And the second one is who are the beneficiaries and where do they live, and obviously where lives the executor of a will, but where are the residents are living. Imagine that the beneficiaries are living in the US. The assets are in Spain, or the assets are in the US, or the assets are in UK. Imagine that the beneficiaries, all of them are in the UK, and most of the assets probably that are going to be inherited are in Spain. So then obviously will be some tax. And who are the beneficiaries? Are descendants. Group 1, descendants, spouse, which has some reductions. In Comunidad Valenciana, we have some big reductions in terms of, let's say, for example, 156,000 euros are not included in the base. The property, which is a main home, which has been living more than 3 years, it has a 95% reduction on the value, with some limits as well. And then whatever is the quotity, as Ignacio said, is reduced, the quotity 99%. So the quotity at the end to pay in Group 1, for example, in Comunidad Valenciana, which is this region in the east of Spain, is very low. I mean, Ignacio and myself, we've been explaining this to many clients, making some simulations on inheritance, and they are surprised of how little in tax they have to pay. And as well happens with the Andalusia area. If Michael joins us in a few minutes, he will be explaining this as well. But what if, I mean, whenever it's non-residents, but it's a different region in Spain, would be applicable all the general rules in Spain, and it's not Group 1, then things may change, because obviously the taxes may be a lot higher. So obviously the first thing is just where are the assets located, and obviously where are the beneficiaries living, in order to, well, mainly apply. And obviously at the end, it always combined with the double taxation treaties. Normally with assets in Spain and you have to pay some taxes in Spain, then would be deducted in the country where at the end the beneficiaries are resident, someone who is accepting or receiving some percentage of a property in Spain. Obviously whoever tax you may pay in Spain will be deducted in any tax that you may pay in your home country. And having said that, we could start, Ignacio and Darcy, if you may understand, Moody. There are some questions I can see. I don't know, you've read some of them. I think we could start, Moody, with some questions about probably the equity release to start.
Yes, I was going to say that, because it looks like a lot of your questions are going to be about the tax and wills, which is fair enough, understandable. But I did have one in advance, actually, because Mary in Altea on the Costa Blanca asking about, I think she's looked into it by the sounds of it, the difference between equity release in the UK and how it is in Spain, because I think she'd looked at it and it was a situation where they pay you a lump sum, but then they own that part of the property. You no longer own the property, but you're allowed to live in it for the rest of your life. This is in Spain. Presumably with the reverse mortgage that Darcy was talking about, that wouldn't be the case. You'd still own the property, right?
Right, that's correct. I believe so. With the reverse mortgage, you carry on being the owner of the property, but with a charge against the property. So I understand that, correct me if I'm wrong, the beneficiaries could either give it away, or just repay the mortgage, correct, Darcy?
Yes, so basically the loan to value, what they take out against the property, the bank will have a charge against that particular amount. Let's say we're talking about 40%, and the bank will have a charge against 40% of the equity of the property. The other 60% will still retain ownership of the owner.
Okay.
So you haven't completely handed it over to the bank then. It's just a
No,
part that you can repay.
Yeah,
That's right.
Yeah, my
Okay.
understanding is like granting a mortgage. The problem, Moody, I find some people after 65, they want to apply for a mortgage, and they're going to say, "What is that for?" And they say, "Well, it's just to make a better life, a better living." You know, if you go for a normal mortgage, you will never get it because
No.
you need a mortgage to apply for, to buy a property, to buy a car, to do whatever project that is solid. If you say you're going to spend the money, they will not get it. So,
No.
so
And also, if
this
you're
is a
65, how many years are going to give you a mortgage for? Not 50.
That's
30
right.
year
That's
mortgage.
right.
But yeah, quite. So this is a way of doing that. So they pay you
Yeah.
a regular sum.
I mean, depending on your age, they will make an offer. Depending on your age, they will say, this is the amount of money, this is the valuation, this is the time, that as a general presumption, because even for the tax office, there is always an average. Tax office works with 89 years old. So you always work out with that figure, right? So I guess for Mapfre and different banks, it happens exactly the same. They work with a figure. How much am I going to last? So there is probably a estimation of life, right? So what they do is, depending on, I think the older you are, probably the better and more accurate they could do the project, because probably is 10 years, they give you, I don't know, from a 200,000 euros, they might give you 100,000 euros. And then, but probably is a good deal, because later on, in 10 years' time, your beneficiary is going to sell that property for probably, instead of 200, 300. So they're still getting the 200, and your parents already enjoy a better life with 100. So I really think that is a family thing, but I think it's an excellent solution to a lot of clients of ours that they said, Ignacio, we want to just make the most out of it. So I think, Moody, I think the equity release in the UK has been more popular, hasn't it? But
It has, but people find out, I think, once it's too late, that it's really expensive, and then suddenly they own a piece of your property, and sometimes it's a lot to pay back, and it's a massive chunk comes out of it when you die and it gets inherited. Because I think that's when it's paid off. It's like an endowment sort of mortgage. I think that's the case anyway. So this would be a good way of doing it if you don't need the lump sum perhaps, but a regular payment seems like the way forward.
Yeah, that's another possibility, isn't it, Darcy? They could pay
Yes.
you on a monthly, like just renting out your property. So they could either give you a lump sum, and they could even give you paying you on a monthly stages, isn't it, Darcy?
Yeah, that was exactly what I was going to say. I was going to say they usually judge things on a case-to-case basis. So, like Ignacio rightly said, the higher the age, the better terms that you'll get. And also you can choose which type of payments, whether it will be a monthly or a lump sum, or you can convert into a life annuity, which guarantees payment for life. So
the only thing here I would add to people, I mean, equity release, you don't have that many banks, that many interested banks with it. So to be honest with you, the only one that they just try to go on a reputable basis has been Mapfre lately, and always under the presumption and agreement that the family agrees, because they don't want any issues, any contesting wills, or any reputation problems. So that's really now I've seen different companies that they do offer equity release, but again, you need to see your project, and you need to have somebody behind you that protects you. I remember talking to one of our clients who were already Mapfre clients. They were very happy to carry on doing this project with you guys, Darcy, because they feel comfortable that they were not going to be let down. Who's behind? They were telling me, Darcy, well, we really don't know whether they're going to sell this charge to, I don't know, to an investor, and the investor is going to kick us out in 2 months, 3 months, you know. And he brought a good point, and I said, well, you've got a point here. You need to know who you deal with the equity release. And when we spoke to Darcy, to your people, I found that it was good as long as the family agrees with the whole concept. But again, Moody, you were bringing a point here that might be expensive or not, but it's a matter of whether you need a loan or not, whether you want to just remortgage your property to make a better living, which I think in the long run might work, because the way the inflation is going, Pedro and everyone here, you never catch up. The inflation is, so if you're asking for a mortgage of 200,000 euros, and the way inflation goes, probably giving back 200,000 euros in the future might not even be a problem for your children if they want to have a property worth double, because we're talking about probably 10. It protects husband, wife, and so is mum and dad, and then still the beneficiaries could pay it off. So I don't know, it could be one of the solutions, not the only one. But what is definitely important is to make a will. I highly recommend people, especially if they have assets in Spain. Yeah.
Okay, I'll let you get on, because I think there's one chap on here. It might take you the rest of the webinar to answer all his questions. So over to you.
Thank you, Murray. Pedro, before you go, Barry's asking me, who do you define as a family if family agrees with equity release? That's a very good question, Barry. The whole concept was created for Spanish people, so they always want force heirs to agree on the project, right? So when we say family, is people in the will that they are happy with, right? If you were Spanish, then we have force heirs. That means my children and my wife are compulsory beneficiaries. And if I want to do an equity release, if I was over 65, they will need everybody to sign, okay? Because the applicable law is Spanish, and therefore the beneficiaries are compulsory, these people, plus whoever I want to appoint in my will. However, in different Commonwealth countries, or even Canada, America, Australia, different ones, you've got the freedom of disposing assets. And therefore, that means that you can leave to whoever you wish. Obviously, there is no force heirs, but I think so far what Mapfre will request is a copy of the will and that the beneficiaries are happy with it. This is as much as I know from an international point of view with equity release from Mapfre. That's us talking to the head office in Madrid, right? Because this project was created for Spaniards, and when the law is different for different ones, the whole point is not to have any contesting will, Barry. Okay, Pedro, I'll let you go on with the questions because we're having hundreds, and please, Lise, and then we could take it on.
Okay, thank you, Ignacio and Moody. There's some, Darcy, I mean, I understand now, I'm reading the chart. Obviously, there are many questions about the equity release, the reverse mortgage. One of the questions says, if you are non-resident in Spain, could you apply for this? I mean, obviously it depends on the company, but it's something that it could happen.
Quick answer is,
it's not going to be your main home, really.
Well, quick answer to that is no. You have to be a resident in Spain, and it has to be your habitual residence for you to be able to take on that.
Yeah, because the concept of I understand is, I mean, it has to be your, I mean, it needs to be used as a released equity, really, or it is like, you know, that in terms of is your home, is not to buy, is not to mortgage it. It is just to, I mean, must be your home, and I understand that should be one of the requirements is to be resident in Spain.
That's right. So you have to be required to be resident in Spain, and you have to be you or your partner or your wife living in the home itself rather than renting it out. That's correct.
Okay.
Pedro,
yeah.
Let me interrupt you.
Go
I mean,
on.
Tony
Yep.
was
Go
saying
on.
good points as well, and I think we covered, but I think it's a good point. What about setting up a will to follow the laws of my home country, the Netherlands? Yes, that's completely right. Again, to make a will, no issues. To have equity release, I understand, and correct me if I'm wrong, Darcy, that they want peace of mind, that everybody's happy. So whoever per law is compulsory beneficiary, they will need to sign that they are happy with it. Otherwise, they wouldn't do it because they don't want any court cases, any issues, or any bad reputation about the consent. So that's really the whole point.
Yeah, Ignacio, it's a
Yeah.
good point. I mean, I understand what you're touching right now. This is in terms of probably companies are obviously informing the beneficiaries of who they are the beneficiaries. Yeah, is that right? Not to accept, it's just to be informed about that.
Being informed, that's the word they're using. And I think Sandrine is asking pretty much the same question. If a husband and wife own a property in Spain and there is no Spanish will, who will inherit the property if there are no children? That's a very good question, Sandrine. And I don't know whether you're British, American, or any country that your applicable law states that you have free disposal of assets. But if that's the case, we just need a copy of that will to pass it on to Darcy and for them to study a project according to the valuation of the property, location of the property, and beneficiaries that they're happy. Probably they might request any beneficiary in the will to sign and be informed and have consent. So a document that you're gonna remortgage the property, and that any beneficiary, if there is any, right, are happy, or as Pedro said, well informed. Okay. Okay, over to you, Pedro. Sorry to interrupt. I don't think there is the microphone, Pedro.
Oh, no, it's okay. It's fantastic, Ignacio. I mean, just I'm going to try to answer and write into Sandrine. And is asking if a husband and wife own a property in Spain and there is no Spanish will. Obviously, if they are residents and there is no will, it will be a Spanish law and will be obviously descendants. If there are no descendants, will be ascendants. And if there were no ascendants, it will be a widow. One who is going to be like the beneficiary according to Spanish law. And there is no will. If there are no children,
Right. I think, Pedro, yeah, I mean, the question that you guys could make is your national law and if you ever made a will, right? You've got a very good point. Here is Sean as well. Hello, Sean. Nice to see you in this forum. What if you change your will after taking equity release? Well, I think in your case, if you don't have children, I don't think there'll be any issue because, Sean, again, this product was created for Spaniards who are compulsory beneficiaries. In your case, if you're British, which I think you are, then obviously the applicable law is free disposal of assets. Now, I agree with you. You could change your will anytime, and but I think is a little bit of fear from Mapfre to have a court case in the future for any compulsory and forced heirs.
Yeah, Ignacio, in that case, I mean, the companies will be including, I mean, will include a clause saying, okay, well, if you change your will and you change the beneficiaries, you have to inform us because we need to inform about your beneficiaries, your new beneficiaries that are according to you, what you say, that will be receiving this right on that property. I mean, that will be some issue. Obviously, this is not like trying to hide or trying to, I mean, will be a compulsory, an obligation to inform, obviously, from the company who is giving you some money to be informed about who is going to be beneficiary because the companies wants to know who they are. If you change, perfect, you can, but obviously they have to have the right in order to inform them as well. Not to accept, just to inform.
Pedro, Tony is saying, what if my wife has children from a previous marriage, but we don't have any children? In such case, could in certain circumstances say the taxpayer non-tax resident in Spain? Now, let me tell you the way we understand it, and Darcy, correct me if I'm wrong, the requirement from Mapfre Santander is that is your main home, main property, you're both resident in Spain, and the beneficiaries, according to your specific law, agree. Now, from the Netherlands, we will have to make sure who are your beneficiaries and who are compulsory beneficiaries. If you have children from different marriage, it doesn't matter. Okay, so the key of the case, if for any of applying for equity release here, is to have a minimum of a will. then as Pedro said, we will need consent for those who are compulsory beneficiaries. Okay, it doesn't really matter whether there are children from one partnership or from the other one. Is according to that law, is there any false heirs? And probably we will need a written statement and consent statement in front of a public notary, or just signing the document at the same time or with power of attorney. But that's pretty much for the peace of mind. Okay. Pedro, would you like to carry on? I don't think the microphone is on.
Sorry about that. So there are some questions I can read this from what if I set up a company and ensure the beneficiary that I choose takes control. This is a matter of residence. If you are resident in Spain, unless you expressly say something different about that, will be Spanish law applied to your inheritance and to your beneficiaries. If you own a company because you buy and you own shares from a company in Spain or outside in Spain, at the end will be a Spanish law apply in order to choose who are the beneficiaries of whoever assets you have. Rights, shares, obviously any obligations, and as I say, Ignacio, any insurance, I mean, will be a Spanish law. So important to advise is to expressly say if you want it to be, I mean, a Spanish law, perfect. If you are resident in Spain, well, you could leave it and well, will be your children beneficiaries, or just write a will according to your national law and change these limitations that we have in Spain. Okay, and
Pedro, let me just clarify one thing, because I think people are getting lost here. First thing that rules your state is your nationality. So that's the number one thing. I know you want husband and wife to take control of everything, but that's only if the law allows you to do. So first thing for you to disclose, to do the project with Darcy, is what nationality we're talking about. Okay. So that's first question. What nationality you are in, so we will understand what are the bylaws that they're going to limit everything. Now, if you're lucky, because you probably guys are more lucky than Pedro and myself for sure, because you have free disposal of assets, which is excellent. So that means you could do whatever you like with your assets, then take advantage from it, make a will, and then leave it all written down, right? Now, if some of you are saying, well, what about if I have no children? What about if I change my will? Right, that needs to be considered by Mapfre team in order to make sure there is not any claim against the state in the future. That's the whole point. And Pedro, we have Bill. Hello, Bill. Nice to see you in this forum. Is there any inheritance tax relief if I leave my entire state to a charity, Spanish or UK? Well, funny enough, Bill, here, we've been the executors of a lot of wills that our clients left it to charity. And the good part of it that there is no tax for Spanish, obviously ONG or a charity, let's put it this way. We have a specific case that one lady, a late friend, Pauline, left everything to Cancer Association in Spain and in the UK. And there is no tax against this charity in Spain as long as they're registered, duly registered. Okay. Okay, Pedro, over to you. Sorry to take your time.
Yes, there are a lot of questions from Michael. Thinking Michael, I would be a resident in Mallorca and I'm sole home owner. I have a partner who is covered with my English will. Will Spanish law accept this? If you're going to be resident in Spain and you have an English will and you don't have a Spanish will, or you don't have a will where I expressly say that the national law will be applied on this, I highly recommend whenever you become resident in Spain, you make a simple will, a mirror, yes, choosing your beneficiary, your partner, for the assets in Spain. For maybe you own or buy a property in Mallorca, I highly recommend you that, because once you become resident, it will be an issue that will be a Spanish law applied to your inheritance on this. Okay. let's go ahead with some other questions. Do I need an attorney to draw up will, or can a notary also do it for me? Well, Ignacio, will always recommend to give a proper and professional advice. You can either go to a lawyer, a specialized lawyer, in order to write down everything that you wish. But also you could go to a notary. Obviously, the notaries are highly prepared in order to write down whatever you understand it should be. And I always obviously recommend the will be signed in a public notary, in a public. If you want to directly go to a notary office, or you want just at the beginning to start with a lawyer in order to write down and to plan everything accordingly, that will be, I would say, to minimize any issue, obviously, that may happen, or any doubts that may happen in the future.
I don't know, Pedro. I mean, the question to Tony. Tony, could you go to a notary? The answer is yes, you could go. Now, are you going to speak to the notary? Probably not until the very last day. So probably you're going to deal with a clerk. The clerks do not advise in general, and that's not me saying, is the clerk from the notary is saying. So I don't know where you go, will you speak to, and whether they will provide you that service that you need. I don't know whether they will do inheritance tax plan. I don't know whether you will disclose everything, and they will advise you accordingly. As Pedro said, what is certain, when you go to a lawyer, then you legalize in front of a public, because the lawyer filters that's everything you wish and according to what you want. Now, could you go to a notary? Yes. Would it be that efficient the way you want? We don't know. I mean, it depends on notary office, depends on clerks, depends on what they're going to offer you. I mean, probably they're not going to do any tax planning for sure. But you could give a try, Tony, and test yourself. If you already have a lawyer, my recommendation is go to your lawyer, and then he will tell you what he thinks. Right, Pedro,
Okay,
more questions you might have here.
Questions, I think there are one question that is by Herbert, and they say they are German citizens, they live in Germany, and they are not Spanish residents and have a property in Quesada. Quesada is in Rojales, in province of Alicante, that is encumbered. We would like to give it away as tax efficiently as possible to their daughter or grandchild. This is a very, I would say, typical situation where someone is non-resident, have a property in Spain, and have some doubts about what will be the tax if I die, what if I live to my children. Obviously, in Valencia community, as Ignacio said, we have a big reduction. Is that right, Ignacio?
Very good. Yeah, and actually, with regards to your question, Pedro, from Herbert, okay, I think this is he brought a very good point here. Is it worth nowadays? Because somebody said here, I think Sandrine said, do you think SAR is going to change the law about the inheritance tax? I mean, and you brought a point. We don't know, but if you look back in the past, they've done it. I don't know whether they change the government, they will do it again. So what does it mean? The inheritance tax at this stage is very, very good when it's group one, which means husband, wife, and children, or parents, okay? Then when it goes to brothers and sisters, and when it goes to nephews and nieces, then you don't want to know, because the figure goes high. So this is number one. Now, I agree with you. This might not last forever. Is it worth it, Herbert, to do a donation? Well, that's a good point as well. I agree with you. If you do the donation, the nation has the same allowance that the inheritance, and you can have full control today because the law is applicable today. So, and you probably save a lot of money and hassle for the future. So, Herbert, you got a very good point. I think it's good as long as you all are happy with it. What I might suggest to you, Herbert, to maintain the legal ownership, the live interest of the property. So that means you do a donation to your children, they can have the title when you pass away, but you are the only entitled to leave, use the property, rent it out, and make whatever you want to do with it while you're alive. But they are the real owners, but they cannot enjoy it. I think Pedro does a great idea.
Yeah, I mean, I always recommend, obviously, in terms of everyone has his own life, obviously, and situation, but in terms of taxes, in this situation, I would recommend not to do it, because you're going to lose power in order to, I mean, whenever you want to sell, whenever you, or maybe buy another property. I mean, it's in terms of that. In terms of taxes, as we don't have a crystal ball in terms of is the following political party, if they win in the following elections, going to change this? We don't know that. Obviously, will you have time in terms of if it's announced what's going to happen to make some changes? Yes, you will have to. I mean, obviously, you need to be updated. You need to be on the information which may happen. But in terms of doing it because it's going to be cheaper now, and maybe in the future it's going to be expensive. But you're going to lose the power in order to, well, the power of being the owner of that. I mean, and selling in the future, maybe, I don't know, use it for a different purpose. I normally, in this kind of situations, I maintain the situation and recommend just not to sell, or not to give. In this case, not to make a gift, and because the inheritance is extremely cheap in these cases. So, but anyway, it's my point of view, obviously, and I wouldn't recommend to do it. But obviously, if someone wants to, I mean, in the future has different issues or on this, but I don't think a point right to do it now. Maybe whenever the elections comes and the other political party is announcing to change it, well, maybe to think about it. Yeah.
It's hard to make a decision, isn't it, Pedro? Tony, you've got a good point here as well. Actually, you're saying here, and let me just make it clear, it doesn't matter that your children are resident or non-resident. So this applies to all of you. So it's irrelevant at the moment whether they are resident, non-resident, European, non-European. Okay, I know it's quite complex because immigration has one side, the taxation has another one, and then succession has another one. But from a tax point of view, taxation is the same. So if you do a donation, it doesn't matter whether you're European, non-European, resident or non-resident. The important thing is the blood relationship, okay? Because donation to your friends, that's a very high, expensive way to do it, okay? So we'll have to discuss that in the future. Another point I forgot, Pedro, I'm not telling people to get married, but probably if they've been living together for long enough, I highly recommend them to go and at least do the registration of partnership. Why? Because you'll be considered in group one. So you are treated like friends at the moment with your partner. You've been always together, you've got children together, but you never married. My recommendations, go and register that at least once in your life. Okay, you don't need to get married, but you need to register the partnership. That will apply you to use all the benefits of 99% off after the allowance of 100,000 euros per beneficiary and after the allowance of 150,000 euros on the property side per beneficiary. So we're talking about 250, and after that, whatever tax comes is 99% off. So it's a very good advice, and I think you should look into it because it's your pocket. Yeah.
Okay,
Pedro.
thank you very much. There is another question I think is interesting. This is in terms of taxes. It says from Peter, it is possible to have habitual residence in Spain and also in another country at the same time. And it says it's in such case, could in certain circumstances state the taxpayer non-tax resident in Spain. So it's really asking if you could be like resident in different countries, but obviously being tax resident in just one country. Yeah, I mean, this is something that we work on that, and obviously in terms of taxes, if whenever someone may be eligible to be tax resident in one country or tax resident in a different country. Obviously, if you in Spain, if you live at least more than half of a year, half of the time of a year, you become tax resident in Spain. But also, it could happen sometimes that you are eligible to be resident in one country and eligible to be resident in another country. And in terms of taxes, there is a double taxation treaties that at the end breaks the rule in terms of guiding you, in terms of being tax resident in one country or another country. One of the examples normally where you have availability, renting or owning a property in which country, or in terms of where is your vital center, where is your economic center, where is your financial, where is your work. I mean, these issues guides you to one country or another country in terms of taxes. But you could be resident, fulfill the requirements of being resident in one country, and as well fulfill the requirements of being resident in another country, yes. But at the end, you have to be tax resident in one country.
Okay, Pedro, I think, well, obviously we have a lot of questions. I mean, probably, Tony, we could put you in touch. I don't know from what area of Spain you're contacting us. And you guys, you could always drop us an email. We could refer you to probably notaries that might be dealing with you. I don't know whether you're in Alicante or you're in Malaga, or I can identify some of you because I know you guys. But we could refer it. I'm gonna just as a summary. Remember, have you made a will in Spain? Yes or no? Important question. 2, what is the succession law that applies to you? 3, what is the tax planning that you had in your mind? How's it going to turn out? 4, do you prefer to do the donation now or leave it for later? 5, live interest or legal ownership? Just always keep an eye on that. 6, do you need a reverse mortgage that is worth it or not? 7, do you need an executor? Do you think it's worth it? So a lot of questions for you to think of. So Tony, if you're contacting us from Benissa, just pop into the notary, see whether they will help you out there. I know for the Dutch, there is one in Alfaz del Pi and one in Alicante we could put you in touch with, but I don't know the ins and outs because we normally deal with them, but clients don't deal with it. There is one that is Maria de los Reyes in Alicante, okay, that I think she speaks Dutch, okay. But again, for every of you, bear in mind, and another important thing, whenever you disclose your assets, make sure you tell your lawyer when you draw up a will about the life insurance policies, if you already told the bank who's going to be the beneficiaries, because when we represent clients on the States, we start having issues and questions. So the more we can live it all as you wish, the better for you. Okay, I'm going to pass over to Muddy and Pedro. I don't know if there is anything else.
It's quite a dilemma you've given people. May save all that money on taxes or get married. I'm thinking about it very carefully indeed. I did have one really gentle question just to wrap up with. I was going to save till the end anyway. It's about wills. So you get a hard copy of wills, obviously. Say you're as badly organised as I am. Where do you suggest they keep it? Where do you reckon it should be filed? With you? With the bank?
Yeah, that's a good question. If you have a lawyer, always keep a copy with a lawyer. The system in Spain, I didn't mention this, but it's a good question, Murray, is very, very safe. So if you made a will, even if you lost that copy, the beneficiaries, whenever we pass away, they will have the death certificate. With the death certificate, you apply to the last will registry in Madrid. That will point out where is the latest will you ever made. And then the original is always kept at the notary office in Spain. Okay, so even though you lost your main copy, it's not a problem. There is the original always stays at the notary office. You could get a certified true copy as you walk away from the signing day, right? But it's always worth it, your loved one or your beneficiaries or the executor and lawyers to have a copy, because a copy doesn't cost you anything. It's peace of mind. And especially copies of the will, Moody, and instructions, because we dealt with a lot of cases that we know who are the beneficiaries, but we don't know about the assets. And the beneficiaries,
that's extremely important.
Yeah, and the beneficiaries are far away. So it's a challenge for us to contact the nieces. That was a quite success. But what about their investment around the world? We don't know. unless they know, oh, they haven't been in contact for years. So who wins? Banks.
Yes.
Yeah,
No,
that's truly important, Moody, because obviously we know all of our clients are regularly our clients in year by year that we deal with all the income tax, and obviously we have all the information really about. But those ones who are, I mean, they come to us and they, oh, someone has. We need you to prepare and manage with inheritance. And obviously, we don't know anything about them. It's extremely important to inform the executor of a will, the albacea contrapartidor, in order to inform not the specifications of the assets, but just where they are. That's just for that. Just that would be important to put at least. We recommend always that in order to give us at least where the assets are. I mean, in case that we don't have them. And because we include in our database in case in the future something happens, we know where to go.
Right, I'm going to leave you here at the emails. Pedro, if you could Darcy yourself and Moody your email, so because we're running out of time. I think Bill brought a very last question that can we do a living will, which means for mental capacity? Yes, Bill, that's possible to make it. And we can organize that for you and tell you where to go and sign. And that's connected to the Social Security hospitals. Okay, so funny enough, that's how sometimes I've been approached because of client of ours have done a live willing, and the hospital just rang us as well about this specific situation. We had a case in Denia Hospital that they rang us because we had a client in Moreira that made a living will, and he was very poorly, and they needed to contact us to make questions. So that's a good point as well. Nothing to do with financial. It's more about the health. But again, it is worth doing as well. I'm sorry to throw you so much information, Pedro, in so little time. But
It's okay. I think we are run out of time right now. We try to be binding on the time, 1 hour. Thank you everyone to joining us. Obviously, we'll be happy to answer you any questions you may be able to send to our emails that Ignacio and Darcy and myself we have include. And well, anything to say, Ignacio and Moody and Darcy, just to summarize?
Yeah, thank you all for sharing good information. Thank you for the audience for listening carefully and learning every day a little bit more about the law in Spain.
Some great info.
Okay,
Thank you.
Pedro.
And we'll see you tomorrow on Bay Radio, of course.
Oh, fantastic.
That's right. That's 4 o'clock, isn't it?
Yes, quite. Look at last minute plug in there. Thank you.
Okay.
Thank you very much, everyone. Thank you.
Thank you.
Bye-bye.
Over to you, Juanfran. Thank you.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate. Search for assets, debts, and existing insurance policies. Give advice on accepting or renouncing the inheritance in Spain. Hand over information on all the related costs. Pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.